So in case this communication was missed, if you're interested in the second session, that's Breakout Room 2, which is Crossed Wires, that's Bridging Generational Perspectives on Legal Tech. It's happening in Royal Palms, that's the room across from us. So you can just make your way there. And then for everyone here, welcome. You know, I think the MC mentioned at the beginning that this is, you know, the empty seats are because most of the audience is online because this is the Digital Transformation Festival. So those of you who are here physically, I don't know if you are not transformed. But yes, kindly, could we just stand up for a minute, please? Everyone. Let's stand up. We've been seated for quite some time. Thank you. And on your tables, if you don't have a table, find a table with people. On your tables, I would just like each of you to just mention the first piece of technology that you interacted with. Let's stand up, please. Find a table and just... Some of you have been seated for 3 hours and you've not talked to your neighbor. So on our different tables, if you don't have a person on your table, please find a table. We're going to have 2 minutes to do this as I give our panelists time to prepare. So find a table and just briefly talk about the first piece of technology you interacted with. Please come and make that announcement.
Ladies and gentlemen, as you keep to interact, we want to thank you for paying attention and we want to disrupt you a little. There has been some little bit of information that has been confusing and we are sorry, but the panel that was said to have been pushed to tomorrow has been reinstated because the individuals that were meant to participate in the panel or the panelists had a little bit of a disorganized schedule. We are sorry, but we are going to reiterate it as follows. The panels are 3 in number. There's going to be 3 panel discussions. And the idea was that we are going to divide ourselves into 3 different discussion groups and we shall choose depending on your interest. So the third one that was earlier on said to have been pushed to tomorrow, Crypto Clash and Compliance Frontiers, Crafting Legal Pathways in the Digital Currency Revolution, to be moderated by Mr. Patrick Mugalula, and having panelists in being Mr. Robert Chirunda and an MTN representative is going to take place in the Acacia room. There is a room just outside here. We are going to guide you below. We are going to guide you on where the room is, but we want to reiterate that there is 3 panel discussions going to take place. So kindly take heed. Thank you so much.
All right, thank you. I've been taking note of those who have not spoken to anybody. You should be able to know the first piece of technology that your neighbor interacted with. You know, and some of you, if you're on a table and for you, yours is a cassette player and someone is saying iPhone 12. All right, thank you so much. You may take your seats now. I hope that those who are online, you will feel free to type in the chat. And I hope we've given enough time for... I think the group next to me wants to share. Yes, I hope we've given enough time for those who would like to attend the other sessions, and we're ready to kickstart this one. So this panel will focus on digital justice on demand, which is tech-driven ADR and ODR for inclusive access to justice. And you know, digital justice on demand, it's not like just a catchphrase. It's rather a call for us to think about the demand for justice in the 21st century and how that's reshaping dispute resolution. So first we had ADR, or alternative dispute resolution, which focused on other ways of resolving disputes away from the traditional court system. And then we also have ODR, online dispute resolution, and in case you're not very familiar with this term, this one focuses more on dispute resolution that happens online through platforms, channels, you know. So a simple example I can give just briefly is like an app that I think some of us have interacted with, which is like Glovo. So for instance, if you order for something and then there's an issue with your order, and I think there's been times when I'm expecting an order and then the rider tells me that like my drink poured. I've seen people who complain on Twitter that riders ate their fries or something like that. But the way it works is if you have an issue, you can contact Glovo through the app. You can, you know, they have a chat feature, chat function, and then that's resolved almost immediately. So either they send you a refund, a partial refund, and so you have a dispute resolution process almost from the starting point, which is when you complain, they hear you, they resolve it, and the matter is closed. We do have an entire law on sale of goods and supply of services, and that would have gone to court for you to get relief, but now ODR allows you to do that online. So yes, this panel is going to focus on ADR and ODR that's driven by technology. And while the promise of technology is exciting, it raises questions about access, about fairness, about inclusivity, and even about sovereignty. So that's what we hope to get into today. And to unpack these issues, we have three outstanding voices that, you know, sit at the intersection of technology and dispute resolution. So allow me to introduce our panelists, and I'll request them to make their way to the front for the conversation. So first we have Honorable Justice Geoffrey Chirabure, who His Lordship currently serving as a Justice of the Court of Appeal. He's a Fellow of the Chartered Institute of Arbitrators. He's a member of the London Court of International Arbitration, and he has written and spoken widely on both alternative dispute resolution and on technology. You're welcome, my lord. We also have Mr. David Kagwa, who is the current chairperson of the Chartered Institute of Arbitrators. That's a Uganda chapter. He's a senior partner at Kagwa & Kagwa Advocates, specializing in arbitration, construction law, and commercial litigation. He is a fellow of the Chartered Institute of Arbitrators, a member of the London Court of International Arbitration. You're welcome. And then finally, we have Mr. Patson Arinaitwe, who is a partner at Signum Advocates. He heads the arbitration practice there. He's a fellow of the Chartered Institute of Arbitrators and a court member of the International Chamber of Commerce's International Court of Arbitration for the 2024 to 2027 mandate. And he's also an ex-officio member of the Commission on Arbitration and ADR. You're very welcome, gentlemen. I think you can see we have, if there's anyone to talk about ADR and ODR, we have a very well-constituted panel of experts, so you'll allow me join them. Thank you. All right, good afternoon, gentlemen. I hope we're doing well. We have the, I don't call it a disadvantage of sitting, you know, through people's lunch, but I think after your credentials, everyone is awake. So just to get us started, I would like to give each of you just a minute to just give us your general overview, or perspective on the state of dispute resolution in Uganda today. Like, if how it is today, if you could just give us your commentary on how you feel the status of dispute resolution, either where we've come from or where we are today, or where, versus where we hope to be. Just give us, an overview. So I'll just start with you, my lord, and then.
Thank you very much for this invitation to come and engage with the Law Society again. It's always a pleasure. This is where we came from, so it's good to be able to see where we are and where we are going. My view about the state of dispute resolution in Uganda is we're moving towards what I would call a state of crossroads. We are starting to evaluate amongst ourselves whether what we are doing is working. If it is not working, how can we do it better? So we are actually also moving through a period that is defined, if I may say so, in line with the themes of today. At every point in time, God puts you in a special place. And we are right now in the period which is known as the Fourth Industrial Revolution, which is the Internet of Things. And therefore, a lot of what is going to define what litigation or what dispute resolution is going to look like is also going to be determined by the time in which we are living. We are living in a time that is like no other right now. It may not seem like that on the face of it, but when you look globally, I think you'll come to the conclusion that indeed we are at crossroads. The question is, which road are you going to use? Thank you.
Thank you so much, my lord. David?
Oh, thank you. The time we are now living in is we're experiencing the realities of the world being a global village. We are seeing cases where the disputes are resolved from various parts of the world. There are arbitrations happening in Singapore or London or South Africa, and we are seeing that some of these disputes are resolved from various parts of the world, but when it comes to enforcement, some of these disputes are coming to Uganda for enforcement. So we've seen some cases from South Africa involving Aya, for example. We've seen cases from London involving Zabo and Great Lakes, Vantage. So many of these disputes are handled elsewhere in the world, but they are coming to our courts for enforcement. So we are seeing that there is now an intersection between dispute resolution at a global stage and our judiciary in Uganda. So it calls for more collaboration and it calls for more conversations. And I wish to thank the Uganda Law Society for inviting Justice Chiriawire. Not only is he a fellow of the Institute, the Chartered Institute of Arbitrators, but he's also a champion of ADR. So we need to have these conversations since we're in the same ecosystem.
Thank you so much, David. Patson?
Thank you, Ruth, and everyone in the room. When we talk about dispute resolution today, I think it's not the same process we had 5, 10 years ago, whether in Uganda or globally. The processes have changed. The players have transitioned in different forms. but also the tools have been made better. But more importantly, the availability of data to help in resolving disputes is amazing. But more importantly, the opportunities that are open now that were never there before. I think we had more dispute resolutions localized. When we talked about a dispute resolution lawyer in Uganda, when I talked about within our jurisdiction. But today, it's a group of villages, like David has said, and it's easy now to resolve disputes across the globe and play different roles, not only as counsel, but as arbitrator, as mediator, as expert determiner. So many opportunities have come up, and the tools have enhanced how disputes are resolved much better.
Thank you so much, Patson. I think that's actually the perfect segue to what I would want to ask my lord next. Is Patson has spoken about the evolution of dispute resolution, the role of a lawyer, but from a judicial perspective, you've served on the bench for quite some time. And I think we're curious to know, one, how the role of a judge has evolved from the way we understood, traditional justice to, now we have ADR, ODR. How is the role of a judge as, the one that sits to adjudicate disputes? How is that role evolving? And is the judiciary aware of this role? And do you think there are new skills that, there's a new skill set that a judge needs to be aware of or cautious of to navigate, you mentioned being at crossroads, so to sort of navigate what we are dealing with now on the dispute resolution front?
I think from a judiciary perspective, I think we need to look at things holistically. It's very difficult to isolate how the judicial officer is operating outside how the litigants are and how the bar is also operating. You use the terms which we now need to begin to define. And I think from a judicial point of view, we have been going through a process that is not dispute resolution. In the judiciary, we had parked around what is called adversarial litigation. When you talk about adversarial litigation, you're just talking about a segment of dispute resolution. So now the idea is, how can we redefine that? That's the crossroads, because you have those who are pushing that adversarial litigation should still take place, and we see it in the courts. We see it how the cases come to court. We see it as how they are litigated. People say, my instructions are to proceed. Yeah. This is language that is what? That is very common. And when they are talking about that, are they thinking about dispute resolution? No. They are thinking about adversarial litigation. Whereas now, especially if you're looking through literature on the subject, you center this around what was in the US referred to as the Pound Conference in the 1970s, where it was decided that adversarial litigation is taking the United States nowhere. And therefore, there is need to rethink what is happening in the courts. And the output of the Pound Conference, which you can look out for yourselves, was we need to move from a situation in the courts where you go to court for adversarial litigation only to a process where you have a multi-door process. A multi-door process that allows people not to line behind one door waiting for one judge to hear the case, but a process that allows people to come, and if they wish to be supported, for example, in mediation, they are supported. If they want to be supported through a process known as arbitration, they are supported. If you want to have a process that is fast-tracked, for example, small claims, then you can also go through those various doors. What does that happen? What happens then? You open up the court system from what was closed into adversarial litigation into a multi-door process. Interestingly, even in Uganda, we still have resistance to go to the other doors. And that's why I'm saying we should look at it beyond the processes of just what is happening in the judiciary. Because the judiciary, for example, has supported the opening of the other doors. There are now rules of court that allow you to go to another door. The question is, are people going to those other doors? You see, because the courts cannot go and say, you go here. Sometimes we push you there, but it is the door that you need to choose which door you're going to go to. Is the judiciary aware of this? Yes, that is why there is this change in the rules of procedure that allows for substantially a different type of court from what it was before. Now, really in Uganda, we have the makings of a multi-door courthouse as well, and the training for that is there. And many people may even have missed the launch of what we call the AJS, Alternative Justice System, which was launched last year in June. This is also going to bring in what I think Minister Mao was talking about, decolonizing our mental state of dispute resolution, going back to how we used to resolve disputes, bring in new stakeholders. Stakeholders are not necessarily judicial officers. We're going to rope in clan leaders, religious leaders, opinion leaders. All of these people should now become part of a process of dispute resolution. The output being, we want disputes resolved more quickly, more efficiently, and more cost effectively. So yes, there is right now as we speak, significant training taking place within the judiciary to deal with this transition. And that is where we really agree with the Law Society. We have a very clear nexus there when you're talking about the changes that are taking place in the Law Society. We also have a transformation agenda in the judiciary. And one of its hallmarks is use of technology. So now we're leveraging on technology. The bar is also leveraging on technology. There we have no disagreement whatsoever. And we should really try ourselves, we should work together to leverage on this point. So yes, we are aware within the judiciary. The other thing which, as I wrap up on this particular point that you make, is I am very pleased to see the bar starting to take lead. There's actually a lot of literature, if you look at the World Bank literature and reforms of judicial processes. There are two approaches that take place. One is bar-led, and the other one is judiciary-led. Now the question is, who is leading who in Uganda? When you're talking about a multi-door courthouse, I think it is the judiciary which is leading. When you're talking about applying technology in the courts, it is the same thing. But now I'm starting to see the bar stepping in. The transformation that took place in the United States was bar-driven. And when it is bar-driven, it is likely to move faster than when it is what? Judiciary-driven. So that's another crossroad that we need to deal with. Thank you.
Thank you so much, my Lord. That was very, very comprehensive and insightful. I think An interesting point you made for me was when you mentioned that it's actually the judiciary that's sort of opening all these doors to alternative dispute resolution, because I think sometimes when we're having the conversation, the picture that's painted may be confused as one in competition with the other, right? Like ADR is going to oust, is supposed to oust, what's the role of the courts? And yet from what you've said, it's sort of a 2 or 3-pronged approach. The bar, the bench, everyone embracing technology, and the judiciary itself, creating these rules to allow, I think, litigants have many options. I think that's interesting. I think, David, I know you're wearing 2 or 3 hats here, but I want to first ask you something from your experience as a practitioner, and specifically from a commercial perspective. What would you say is either like a driving force or an incentive for businesses and practitioners to pursue tech-driven ADR and ODR? Like, would you say that you've had any experiences, like tangible experiences, whether here or in Africa, where you can point to actual benefits? I mean, His Lordship has spoken about efficiency, cost saving, quick access to justice, maybe it's enhanced user experience. Do you think you could share 1 or 2 tangible examples of where tech-driven ADR has delivered better solutions for clients?
Thank you very much. As a practitioner, right from the changes that have happened in Uganda, we are seeing that our courts, I think it started with the commercial court, have visual audio services. So it's much easier now to have a hearing with your client anywhere in the world to give evidence. So it's obviously less costly, but also the alternative dispute resolution services like mediation and arbitration. There are guidelines now on the use of virtual hearings, and they have made many of these hearings very, very efficient. A big number of the arbitrations, people don't have to move anywhere. You only get to know that a decision has been rendered maybe when it is at the level of enforcement, but you find that the parties did not move at all. So it has really made many of these processes very efficient and cost-effective.
Thank you so much, David. And I think, Patson, just to get your way in there as well, you head the arbitration practice at Signum. I think we're just curious to understand also from your experience, how has technology changed the way that you resolve disputes for your clients or deliver solutions to your clients? Do you have like a practical, tangible experience that you could share? Yeah.
Yeah, thank you, Ruth. If 10 years ago you asked me if I would sit in Kampala and cross-examine a witness in Nairobi and consult with a co-counsel in London before a panel in Paris, I would think you are dreaming of some science fiction. That is something that was a bit difficult, which has been accelerated probably in the last 5 years, especially post-COVID. And I think for me that has been a game changer, considering the fact that among the things that was affecting especially African practitioners at the global stage was sometimes issues to do with physical hearings in as far as special arbitration is concerned. Either you'll have visa restrictions or having challenges in terms of movement, or including preparing pleadings, and you have to clear them across different continents depending on where the tribunal is or council. So one of the things that has really enabled us is the fact that you're interacting with the ecosystem that is on your laptop or in your hands, and you're able to, first of all, to cut costs significantly because you don't have to do a lot of paperwork, but also navigating through voluminous pleading, especially in arbitration, by using AI that is able to prepare for you, summaries, graphic representation of what has been prepared, makes life easier, and in a way you are able to have a much shorter turnaround time. I think the demands now of clients is not only to deliver service, but also in a timely manner for them to be able to make business decisions. And tech has enabled that significantly.
Thank you so much. I think it was important to get those practical perspectives from those of you who have been in practice for some time now, because sometimes when we talk about tech-driven this, AI-driven this, sometimes there's a tendency to think it's just the hype or it's not yet here. But it's good to hear from you that not only are your methods of work changing, they've been made easier, but I think another thing for me that stands out is that I think clients' expectations are also changing, so they expect faster results, easier results, better results, which depending on which side you sit may be a good or a bad thing. Thank you so much. I would like to come back to you, my lord. I think it was in the address of the chief guest where he mentioned, Chairman Mo, he mentioned that there has been significant developments in the judiciary with technology that are not being given enough, recognition. But yes, we've talked about how we now have ICMIS, we have virtual hearings, which are all notable and commendable developments. But of course, we can't be oblivious to the fact that some of these developments are only being felt within the central region, which I mean, like anyone would say, any development is gradual. But I think we would want to understand from your perspective as someone sitting on the bench, what you consider to be the biggest hurdles in extending some of these services outside, the central region. Is it an infrastructure problem? Is it a cost problem? Is it a cultural problem? For us to get ICMIS at scale all over Uganda, for us to get virtual hearings at scale all over Uganda, or first we have to fix like the power and the internet and things like that?
This may sound a strange answer. I would say all of the above. There is clearly a problem with the infrastructure. You cannot have a digital presence unless you have good internet access, you have good power. We even have courts which are enabled, but they struggle because of what? These infrastructure issues. But there is also one item you did not really get into. Perhaps you can talk about culture, but that, for me, I like to put it under the heading of change management. Mm-hmm. There is also significant fear of technology. There is also resistance to technological tools, and this is born out of the fact that for you to be enabled, you need certain type of equipment. I'll give you, you talked, for example, about ICMIS, mm-hmm. and you can file online. If you're going to get a good quality pleading filed through ICMIS, you need some basic equipment. The app on your phone may not be the best. May not be the best equipment to use. So you get documents which are zigzag because someone is shaking as they are taking the scan. People need to invest in this because this is your future. If you're going to say I'm going to have a technologically enabled law firm, it means that you also need to invest in that one. Mm-hmm. What we have done in the judiciary is to set up a few kiosks, what we call kiosks. So if you are not having the equipment, you can come to us and use our equipment. But this is not going to be there forever. The policy direction is that it is for really indigent people who are coming into our court system who should use it. We are holding hands for the rest of the bar, but there will be a cutoff time. I can, for example, announce today that the cutoff time for using the center at the Court of Appeal will be at the end of September this year. So if you are from a law firm, would expect that you have your own equipment to deal with that. We have provided this equipment for nearly 2.5 years. And I think some people are very comfortable going there, but this is not what it was originally set up for. So there is this need to manage the change in terms of how you're going to use the technology and how you're going to benefit from it. There are also issues of ethics. We're also building that one around. We're having some of the technology being abused. For example, online hearings where sometimes you have people in the corner and prompting witnesses. So there are certain things which we are trying to correct over there. But certainly, it is our desire that this is rolled out countrywide and that everybody should be able to benefit from it. But there are certain components that are there which are already, I will not say that all the functionalities are available countrywide, but there are some functionalities that are. So for example, payment of court fees. You can now, as long as you have a mobile phone, and you know the mobile phone coverage in Uganda is even higher than some developed countries, you can use that. So the question of having to go to a bank to pay court fees has significantly gone down. And by the way, non-tax revenue has just gone through the roof ever since ICMIS was introduced. There's so much money being collected. We were in shock. We were wondering what was happening before. That's a very big question, but I won't go there. But the point is, some synergies are starting to happen. For example, tax collection has gone up. And this is not just for the Kampala area, it is countrywide. Yeah.
Thank you so much. I think it's very comforting to hear from you that the bench is alive to some of these discrepancies. I mean, some of the initiatives that you've mentioned where you open centers to, facilitate those who may not have equipment, or, some of the, at least the awareness of the need to go countrywide is very comforting to hear. And I think now that we have that perspective from the bench, I'd like to task David as, in your capacity as chairman of the Uganda chapter of the Chartered Institute of International Arbitrators. I would like to know if the Institute and its members are aware of some of these discrepancies and the fact that some of these initiatives can, inadvertently exclude some members of the population rather than include them. I mean, as we had, if the mission is to democratize and, through digital transformation, the idea should be that everyone in Uganda has easy access to justice. But I mean, I'm sure you've had commentary before about how arbitration excludes some people because of the formalities and the cost and the processes, and then even online dispute resolution. I mean, some of these platforms are only used here. So I think my question to you is, Is the Institute aware of these discrepancies, and what initiatives or what measures are being thought about or talked about or being implemented to make sure that we do not, further exclude populations that are already struggling with access to justice?
Well, thank you. If you're looking at it from the Ugandan context, we were just launched 3 years ago, the Charter of Arbitrators, and we've raised our numbers from 25 at the time of the launch to 150 now. But it's no longer a Ugandan thing. The Chartered Institute exists worldwide. It's a network of 18,000 people in all over the world. So the members are definitely aware, and there are always initiatives that are set up to guide the members on what happens in technology. For example, this year, the Chartered Institute launched guidelines on the use of artificial intelligence, and they were widely disseminated. There are guidelines on the use of virtual hearings. But I must confess, in Uganda, we have an office in Kampala. We don't have an office anywhere else. So for us to be efficient and to be able to send out this message, we can only do it through collaboration. The judiciary exists in every part of the country. We can only achieve our mandate if we have a collaboration with the judiciary on dispensing justice. Thank you.
Thank you so much. And hopefully, some of these conversations and having representation from different parts, different players is the beginning of that collaboration. Patson, I would like to give you a difficult task to, take us through the hard question on enforceability. So when we're dealing with ADR and ODR, you've had the critiques, you've had the cries, I'm sure you've seen the commentary, recent decisions, people mentioning how after going through those expensive processes, some of which we can't see, we can't read, it's happening at the London Court of Arbitration. People who have received awards come and they're struggling to realize the fruits. People always say in very simple terms is a court gives you an order, you have it sealed, you go to the beliefs, you have your fruits are right in front of you. But the process is to have an arbitral award recognized and enforced here. Very many people have found challenges with that, such that sometimes it seems like that's an exercise in vain altogether. So I just want you to just speak a bit about that and help us understand, what's the value of pushing for ADR and ODR if we're still struggling with enforceability, and do you see any hope in that regard?
Thank you. I think that's a progressive question, especially in light of the fact that our practice hasn't fully moved to integrate and have technology as a core. So when you talk about dispute resolution within the context of AI, within the context of online, I think it becomes important that the issues of enforcement, especially with the arbitral law of the seat, becomes important. For instance, when you talk about enforcement of an arbitral award, having a signed award is important. Now the issue is that if you embrace technology, how do you actually sign? Or, the New York Convention and probably the ancestral model law requires that the agreement must be in writing. How do you pass that standard when you're embracing technology? And the beauty is that when you look at the convention, which is the framework, the New York Convention on Enforcement of Awards, or the ancestral model law 2006 and the amendments that have come through, they're not restrictive in nature. And in most cases, we have to revert back to the seat and whether the award will pass the test of enforcement at the seat. And that's why, as you embrace technology, you have to be mindful, how do I authenticate the award for purposes of enforcement? How do I pass the test of must be in writing, must be reasoned, must be signed? And I think most of the national legislations have embraced the aspects of e-signature, so that when we're applying the law of the sit on enforcement, it is easy to consider those. But also quite a number of countries, UK, Singapore, and of recent Nigeria, have tried to now to amend their legislations to ensure that technology is embedded as a tool, not a substitute. I think currently there's an application before the courts in California where a party is challenging the enforcement of an award principally because the arbitrator substituted the mandate. He used AI in his award to the extent that there was abdication of his duty to adjudicate the conflict or the dispute, and delegated it to AI. And that is some of the critical aspects that might come up. So as we embrace AI, we have to be mindful of the enforcement challenges that might come, but also the standards globally that are helping with shaping how to ensure that whether it's about in writing, whether that one should be signed, passes the test. And I think generally there's a progressive approach in most jurisdictions to adopt such measures.
Thank you so much. You actually mentioned a number of, I think you mentioned good progress in the arbitration space. I think it's even more worrying, I think, or at least younger, in the online dispute resolution space, because someone would ask, if Amazon or Adobe has said I'm entitled to a refund and I'm not getting my refund, who do I talk to, or how do I get that enforced, or how do I get that, recognized, which I think some of these we don't have answers to. But from where you ended, I would actually just like to throw it back to you, because you actually are serving on the ICC's International Code of Arbitration. And I just wanted to know if there's any, whether it's tools or strategic priorities at that level, the International Chamber of Commerce, that they're either adopting or they're starting to embrace, that we can either take from or start to see where the future is heading in the adoption of technology for ADR. Is there something you've seen that you think we should start to think about?
Yeah, thank you. Of course, the ICC's International Court of Arbitration has been at the forefront on a number of developments in international arbitration. And I think we are in good times where a lot is being championed. And I think early this year, the court rolled out a case management system called Case Connect, almost equivalent to our ICMIS, but in such a way that it makes life easier, not only for the tribunal members or to the court members, but also to the users. And with practice directions and on how to use the system. When I was appointed, I think it was one of those daunting experiences when, part of the mandate, for instance, is to review a draft award or scrutinize it. It's around, 600, 700 pages. And you're wondering why members from the other jurisdiction can turn around a report in a couple of days. Yeah. Until I realized that probably I was the only one who was still analog, in terms of catching up with the processes. But, with the orientation, which I believe they also take every member or the user through, it helps to transition someone into the ecosystem that helps access justice within that space, very well. But also the fact that even when AI or technology has been embraced as a tool, I would want to emphasize the issue of a tool, yes, is the fact that the integrity of the process hasn't been, compromised. To say you need to be aware of the challenges of technology, but also ensure that, the processes you roll out are very critical. And I think for ICC, the process of scrutinizing awards is something that they've embraced, very well, to ensure that, due process has been followed, and to ensure that whatever award is rolled out by the tribunal members is enforceable, especially under the New York Convention. But also they've rolled out the state-of-the-art hybrid conference center in Paris, very magnificent infrastructure that allows, both in-person hearings, but also, online for whichever users, depending on, on the jurisdiction. I think the other key concern has been the studies of recent. I think there was a study with Ernst & Young to see how, users of the ICC and other arbitral institutions can embrace technology. What are the concerns? What are the developments? But also to ensure that, the justice system within the arbitral process is not, people are not enslaved, but you have, constant, development, but also checks. Of late, it is easy to check the conflicts of an arbitrator, whether an arbitrator is conflicted or not, through, AI, something that was very difficult years back. You had to invest a lot of money and time to track down whether or not an arbitrator is conflicted, which now with systems, makes life, easier. Yeah. So those are some of the key developments that I've seen happen at the ICC.
Wow, I'm not sure whether to be excited or intimidated, but yes, I think, David, I would want to ask from a Uganda perspective. I know you mentioned that when we're dealing with the Institute of Arbitrators, it's beyond, Uganda, it's now international. But I think I'm curious, based on what Patson has just mentioned, some of the examples he's given, is there any new accreditation, any training, any, being run by the Institute or championed by the Institute or fronted by the Ugandan chapter of the Institute to sort of equip its members to make sure that, they're not like Patson that are, reviewing, going through documents for 7 days rather than, like a shorter period with AI? Is there anything happening or accessible locally or by people here to equip themselves in the tech space?
Yes. First of all, to have access to these trainings, you need to be a member of the Institute. And this year alone, we have scheduled 4 trainings that pathway courses to become a member of the Institute. We already conducted the Accelerator to Member in July. We have the Accelerator to Fellow in November. We already conducted the introduction course in March, and we have another introduction course in December. So the first step is to undergo those trainings. You become accredited, and once you are accredited, then you'll have access to a network of various professionals, and we have continuing legal education. But more importantly, we have in November 13th and 14th the first international CIAB conference in Kampala. So we have delegates from all over the world who are going to come to Kampala for this conference. It's mainly about changes in the arbitration space. As you know, a big number of infrastructure development is happening in Africa. So the entire world is interested in what's happening in Africa. So we should be equipped in order to make sure that the people from London should not take what should be Ugandan business. We need to have the capacity to be able to embrace knowledge and technology to be able to participate in the growth of the infrastructure in Africa.
So basically, there's no excuse. I think you almost have like quarterly trainings. Thank you for that. Malo, just to wrap up on this point, we want to understand from a, again, judicial perspective, with what's happening elsewhere in the world. We've heard of different technologies being adopted. You mentioned small claim courts, right? In some countries, these have been made purely e-courts. No one has to show up at all. And then we've also had for some time now in some countries, there's AI-powered tools that are being used for sentencing. I think Patson and David may have mentioned, substitution of, using AI to either prepare an award or parts of an award. We've heard that these tools can be used to, have standardized uniform sentencing. And of course, we recognize that we may be at a certain pace of our development. You talked about change management, so we're cognizant to that. And so we may not immediately jump to some of these developments, but do you think that there's anything you've seen or heard in your research from what's happening with technology in courts elsewhere that we could borrow from or look at in terms of improving our systems?
Yes, the use of AI, and in particular generative AI, really is possible depending on the quality of data that you have. So the ability for you in a Ugandan context to use generative AI also is determined by the amount of data that is available around that subject. Because data, generative AI creates its own content based on the data that is out there. So that is one of the areas which we need to brush up on. But there is a lot of literature where generative AI is now taking center stage in judicial processes. You mentioned sentencing. Here in Uganda, we have, for example, sentencing guidelines. And there has been some challenges with those sentencing guidelines. But if you look at certain parts of China, for example, trials are taking place, but sentencing is being done by generative AI because they have every possible scenario that can exist in terms of a crime that has been committed. So what the generative AI needs is a verdict of guilty. Then it will take it from there. It will be able to analyze your age, to be able to analyze your mitigating factors, your aggravating factors, to be able to analyze the other parameters that would be necessary in doing that. And that is very helpful for China because just population-wise, it will be almost inefficient to do that using human capabilities. We can actually use generative AI right now in Uganda to draft your judgments, but the quality of data will put a very big question mark. You've heard of cases even in the United States. I think there's the Matter case, which is very popular, where an attorney was sanctioned for putting out submissions which had fake authorities. That one has gone out. Now, it's not that the generative AI just conjured that authority. It is that authority actually was there in the database that is existing. So some lawyer some attorney must have used a fake decision around that area and may have been even accepted. So the generative AI picks it up and puts it in your submissions. You do not cross-check. And I think this is what Minister Mao was talking about, that sometimes even when you have these, you need to go back and check for efficacy, what is happening. There is great potential. There's great potential in using AI in doing some of these things. And for example, now I can also let the bar know that we're in advanced stages of creating what is going to be called the JWT, the Judgment Writing Tool. This one is already being configured for the Ugandan judiciary, and part of the things that we will look into is just to what extent we can leverage AI for it. So very soon, the judicial officers will have a judgment writing tool that will help them to write judgments faster and also in a more standardized way, which is important because now if you're going to start being able to use that consistently, the more it looks alike, the easier for AI to what? To use it for your benefit. So yes, we are seeing a lot of progress internationally. We're not seeing that much in Africa, but we're starting to see the baby steps towards also leveraging on these areas in terms of, for example, judgment writing. I think this, by about this time next year, should be operational. Summarizing documents, that is also very common outside. I think you can do that yourself. Some bit of data analysis can also be done. Look, it's a question of interest. It's a question of interest. The more interest you have, the easier it is for you. Now, what has happened in other countries, which is not very common in Uganda, is there are companies which have come up with AI-driven programs which you can buy. In the United States, there is CoCounsel, for example. You can use that. There's Cloudy. You can use that. There is Case Text, which you can also use. Now, these tools we don't have for Uganda, and most of these tools are used in the U.S. both state and federal systems.
Wow, thank you so much. That's also very enlightening. Some of the things you mentioned, I'm actually going to base on to come back to you for my last round of questions, which is the issue of bias. I don't think we can talk about, ethics. I don't think we can talk about technology without addressing, the ethical issue, both from a bar perspective and a bench perspective. There are issues to do with technology and ethics. When you were describing some of these tools and some of, what's in the works, I could already see questions being raised about things like the right to a fair hearing, or being able to, like I think someone mentioned earlier during the opening about empathy and the place of like human wisdom and experience and context. And then, there's all this talk about AI bias, although some other people will tell you AI eradicates human bias, which we've complained about for years. So I think I would want to start with you on this ethics question from a judicial perspective. Do you think there's a balancing point somewhere? Like, do you think we can have the technology, the faster, speedy justice, cost-efficient justice, but also maintain some of those core values? Do you think people will feel like they've been fairly heard if they know that the judgment was partly developed by AI, or that they weren't in the room and didn't get to make their case? Do you think there's a balance there?
Actually, that is a very big subject matter.
Yeah.
It's such a huge bifurcation, if I may call it that. On the one hand, the speak is justice, delayed is justice what?
Denied.
Denied. And so there is this move towards efficiency and effectiveness using technology. But out of India came another phrase that justice hurried is justice buried. So we're in the middle of those two interfaces in terms of technology. Ethics is the biggest question now. Ethics, issues of privacy, biggest issues around use of AI in courts. In fact, I would just refer you to the European Union, which has come out recently with a convention, I believe, on ethics around use of what? AI in court. that gives you some, if you read it, it will give you some of the thematic areas that are out there. I've already told you that AI uses existing data. So if the existing data is already biased, for example, in the US, it can be comfortably said that there is a bias that certain types of people are more likely to commit crimes than others. Now, if you bring that data into a Ugandan system, you just get into a lot of what? You get into a lot of trouble. So the data cleanup is very important. You need to know what data you're dealing with, because the people who generate the data also have inbuilt biases that can unintentionally move into the other domains that are being used. The data is being used. So that's a big problem. The other question, which is fundamental, I think, is: are you going to use this for purposes of replacing yourself or enhancing your skill? When you're saying you're going to use technology, are you going to say, I want technology to replace me? That's a big question, and it is live. So, for example, there is, I don't know if you have been following the case of the program known as Do Not Pay in Illinois. It is an AI lawyer and is taking over a lot of roles of lawyers, attorneys, in areas like Chicago. In fact, the bar was so upset with this program that they took it to court and said that Do Not Pay was practicing as an attorney in Illinois without a practicing certificate. And the bar lost the case, basically meaning that Do Not Pay can be used in court. So now people are able to have this program, and you can put an earpiece there and speak and say, I want to know about this area, and the counsel opposite is talking about it. Then it gives you a very quick brief on it. Then you stand up and say, objection, Your Honor. Counsel there is misleading court, and you are wondering, this vendor of the street, how can he do that? But those are the things. There's talk of AI judges. So the future perhaps may look very unnerving, but of course we're not there yet. My response, really, in summing up, is this is an ongoing debate that is taking place, just like even before technology came. The best practice of law is one that is ethical. That should not change because technology has been brought into the picture. Thank you.
Wow. Thank you so much, my Lord. As we wrap up, just to turn to you, Patson and David, we've heard about ethics from the bench. I think you can see how heavy it is. I understand that it's a very heavy, comprehensive question. I think I just want to ask for your perspective from the bar. I mean, you've had the issues. We have confidentiality. You have people uploading their clients' documents very carelessly on some of these tools, and then you have them out in the open. You've had issues of, the fake cases being cited. But even just, we've had conversations about billing, the billable hour, right? Are you still billing clients for an hour when you're using AI to do their work in 2 minutes? Are you disclosing that you're using AI to them? Are they comfortable with it? So I think I just want to ask you, as you sum up, either of you can start, just from your perspective, what you think lawyers should be cautious of from an ethical standpoint as they adopt technology.
Well, recently there was an award set aside from a retired judge in India. Basically copied and pasted his decision in a previous case with similar facts, put it in this other case. And at the setting aside application, the argument was that the judge did not apply his mind in regard to this particular set of facts, and the award was set aside. 2 weeks ago, I was conducting a training on construction law, and at the end of the 2-day training, we set out 25 multiple choice questions, and they were based on the FIDIC conditions of contract. So I made an experiment. Of course, I knew the answers for all the 25, so I made an experiment. I picked the 3 FIDIC books, put them in ChatGPT, together with the questionnaire of the 25. And it had 23 answers correct out of the 25. So about 2 years ago, the Chartered Institute in Brazil made an experiment. So certain students were versing ChatGPT to do a moot on an arbitration case. It was an experiment. And ChatGPT was very accurate regarding the structure of the award, because the award has various structures, right from setting out the procedure history to what happened, to the factual background. It was very accurate regarding all that. And yet those are very important components of an award. It had errors definitely in the reasoning, and it's most likely because of what Justice Chidabida said. The availability of data at the time they were using it most likely was inaccurate. So at the reasoning, it made errors. So on the ethical point of view, we need to guide ourselves that we use it as a tool and not abdicate our duty to it 100%, because it can be wrong, but also it can be efficient. So we have to be mindful of the existing guidelines on how to use AI, so that we are mindful of the ethical aspects of it, but it's a very important tool for efficiency in delivery of justice. Thank you.
Thank you, David. Patson?
Yeah, if I may add my voice to the issue of ethics. I think the starting point is to appreciate that AI has come to stay, and it's a very good enabler in the way we do things, especially in the dispute resolution space. Having said that, I think it's also important to appreciate that AI is an assistant, and a lot of information that comes from there should be secondary, not the primary. What that means is that while you might use it heavily in the process, the decision should always remain human. The individual involved should own the decision in whatever the circumstance. But also appreciating the fact that the ecosystem of AI must pass certain fundamentals, especially if we're dealing with the arbitration space. How are you dealing with the issue of party autonomy, fairness, confidentiality, or aspect where you need to do disclosure, have you actually done the disclosure? But also knowing that there has to be an element where human interaction has to stay. If you're dealing with a heavy duty arbitration, and you know cross-examination is very critical, you want to test the demeanor of a witness, you want to study the temperature in the room, probably you may at some point to say, okay, instead of going virtual, in person might be very, very important. Or in mediation, you want to ensure that prior you can reach a settlement, and maybe the in-person discussions are very critical instead of adopting AI, generally. So the critical aspects have to be kept intact as we embrace AI, so that we are not caught off in terms of ethics. Considering the fact that in dispute resolution space, integrity still remains a core component, whether you embrace AI or not, as His Lordship has mentioned. So after appreciating that this is just an assistant, then we must test ethical consideration at every stage as we embrace or as we leverage on technology that is a very good tool and indispensable justice.
Thank you so much. Unfortunately, because of time, we do not have time to take questions, but we've tried to cover as much as possible, and hopefully you found this discussion enriching. I think just to sum up, as Justice Chiremire said, even before technology, the best practice is the one that's ethical. I don't think there's anything I can add to that. So thank you all. And thank you to our panelists.
Thank you so much, our dear panelists and the moderators. We are grateful for the great wisdom and knowledge you've shared with us. I think it's time for lunch, which is going to be at the Sunset Restaurant. And we shall be back here by 3:40. And we have some exhibitors outside for those people who are leaving. Thank you very much. We pick the coupons at the registration tables, and we have our lunch. Thank you.